Imagine a client sitting across your desk. They were married only 4 months ago. The relationship has collapsed completely, and they are demanding an immediate divorce. Your immediate legal advice has to address a severe jurisdictional hurdle. Under Section 3 of the Matrimonial Causes Act 1973 and its civil partnership equivalent in Section 41 of the Civil Partnership Act 2004, their request is legally impossible. This statutory bar is absolute. The law strictly prevents any application for a matrimonial order within the first 12 months of the union. As outlined here in Section 4C of the module text, this one-year bar explicitly restricts the initiation of divorce or dissolution proceedings. This restriction applies without exception. The severity of the relationship breakdown is irrelevant, and the fact that both parties might mutually desire to sever the legal tie immediately carries no weight in court. The practitioner's primary responsibility at this stage involves navigating a mandatory period of statutory restriction, managing a crisis where the ultimate legal remedy remains unavailable. The legislative intent behind this one-year block is rooted in public policy. The state imposes this delay to prevent over-hasty decisions and to provide a structural protection to the institution of marriage itself. However, Section 3, subsection 2 provides a critical practical caveat. While you cannot file the application yet, you are fully permitted to collect evidence and rely on the events occurring during this first year once the statutory clock runs out. Effective short-term advice requires deploying alternative legal procedures during this restricted period, all while actively preparing the file for the rigid timelines that will dictate the second year. Understanding this procedural timeline means analyzing the specific stopgap measures available in year 1 and the mandatory procedural gateways that open in year 2. A practitioner proves their value during this first year through their ability to secure proxy remedies for the client while the 12-month clock ticks down. The primary strategy available within the first 12 months is an application for judicial separation, governed by Section 17 of the Matrimonial Causes Act. Looking closely at Section 4E in this text, we see the critical procedural distinction. Unlike divorce, judicial separation is expressly available during the first year of marriage or civil partnership. The legal effect is highly specific. Under Section 18, subsection 1, an order of judicial separation officially terminates the duty of the spouses to cohabit, but it leaves the legal framework of the marriage entirely intact. Because the marriage has not been dissolved by the court, the parties' legal status remains restricted. Neither party is free to remarry. This split-screen comparison illustrates the financial reality. While a full divorce opens the door to all potential financial orders, judicial separation allows for most property and maintenance adjustments, with specific critical exceptions. Notably, pension-sharing orders are entirely unavailable in judicial separation proceedings. There is a second, highly specific alternative during year 1, the law of nullity. This applies to unions suffering from severe structural defects in their formation. According to Section 3 of the syllabus shown here, nullity bypasses the one-year wait by arguing a different legal premise, that a valid marriage never existed in the first place. A void marriage is one that never took effect in law. This occurs in cases involving bigamy or when the parties fall within prohibited degrees of family relationship. No formal court order is strictly required to end it, though one is often sought for clarity. A voidable marriage, conversely, remains valid until a party actively obtains a court order to annul it. Grounds for this include a lack of valid consent at the time of the ceremony or non-consummation of a heterosexual marriage. These applications carry their own strict procedural deadlines. For most voidable grounds, the application must be submitted within 3 years from the exact date of the marriage. Nullity requires a high evidentiary threshold. If the legal formation of the union was technically perfect, nullity is unavailable, and the practitioner must return to managing the chronological wait. Once the calendar reaches exactly 12 months and 1 day from the date of the ceremony, the jurisdictional bar finally lifts. From this point forward, the process is governed by the Divorce, Dissolution, and Separation Act 2020. This module text explicitly notes the effects of the 2020 Act. Most importantly, practitioners no longer need to prove one of the traditional 5 facts, such as adultery or unreasonable behavior. The modern application relies on a single ground, a formal statement that the marriage has irretrievably broken down. This statement can now be submitted by a sole applicant or jointly by both parties. This joint application process stands in sharp contrast to the previous, inherently adversarial system, where the legal mechanism required one party to formally assign blame to the other. Under this no-fault regime, a respondent has exceptionally limited grounds to dispute the application, usually restricted entirely to challenging the jurisdiction of the court or the initial validity of the marriage itself. While the legal requirement to assign blame has been removed, a rigid statutory waiting period has replaced it as the defining characteristic of the divorce procedure. The law now enforces a mandatory cooling-off period. This structural delay ensures that the decision to permanently dissolve the union is deliberate and finalized. Section 4D of this document outlines the first major milestone, a minimum wait period of exactly 20 weeks from the date the application is issued before a party can apply for a conditional order. For the practitioner, these 20 weeks are highly active. This is the period designated for negotiating the complex financial settlements and establishing formalized child arrangements. The conditional order serves as the midway point of the divorce. It is the court's formal confirmation that the legal requirements to end the marriage have been met, but the marriage itself still remains intact. Looking at the top of this next page, we find the second mandatory delay, a minimum wait period of 6 weeks and 1 day from the pronouncement of the conditional order before the applicant can apply for the final order. The final order is the decisive document. It legally severs the relationship, changes the party's status, and allows for remarriage. If an applicant deliberately delays and fails to apply for this final order, the respondent is granted the right to apply for it themselves, but only after enduring a further 3-month statutory delay. Practitioners must ensure financial remedies are resolved before this final order is pronounced. If a party remarries before filing their financial application, they trigger the remarriage trap, permanently barring them from claiming property adjustments or lump sums. From the first day of the marriage through to the final order, the process is a series of statutory gates. Each gate requires specific documentation, and each opens only with the strict passage of time. Reconstructing the full procedural roadmap reveals exactly what a client faces when seeking to end a short marriage. Reviewing the module's earlier sections, the Year 1 phase requires managing the absolute Section 3 bar. The practitioner must assess if the severe threshold for nullity is met, or deploy judicial separation to resolve immediate financial and living arrangements. Revisiting the final steps shown here, the Year 2 phase activates the 2020 Act's timetable, an initial 20-week wait, followed by the conditional order, and the final 6-week delay. Managing client expectations is crucial. Even if an application is filed on the very first permissible day, the process will take at least 6 months. These timelines cannot be expedited. Neither wealth nor mutual agreement to separate can fast-track the mandatory cooling-off periods. In this area of law, the practitioner operates as a strategic time manager just as much as a legal advocate. Accurately forecasting this rigid timeline and explaining the limitations of the available legal tools is how a lawyer builds essential trust with a client in crisis. The statutory timeline balances two competing forces: the individual's legal right to exit a relationship and the state's interest in ensuring that dissolution is measured, deliberate, and non-impulsive. Success in family practice requires selecting the correct statutory tool for the exact chronological moment the client is experiencing. Deploying proxy remedies too late wastes resources, and applying for definitive orders too early triggers immediate dismissal. Mastering the intersection of the 1-year statutory bar and the modern procedural timetable forms the operational foundation for any practitioner advising on the legal dissolution of an adult relationship.